Hello, good morning or good afternoon, depending of the place where you are. So I believe most part of the participants already connected to and are already joined our webinar. I would like to remind you that today we have nearly 30 participants in our webinar. I told it before, but in case you want to share any comments with us, in case you want to give us your opinion about the webinar, in case you have any question that you would like us to comment, please send us an email to Nicole, to me, or to the email address that was provided in the invitation email that we sent before. Okay, so today we are going, thank you so much for joining our webinar, first of all. And today we are going to talk a little bit about the transfers of personal data between the European Union and the United States of America. In particular, we are going to talk a little bit of Privacy Shield, and if Privacy Shield is still reliable for the companies that intend to share data with a company or with an organization located in the United States of America. Okay, so basically we are going to talk a little about the principles that the GDPR has regarding the data transfers to third countries, and afterwards we are going to discuss the United States of America backgrounds, namely what about Safe Harbor, what about the Snowden effect and the Schrems case and the impact of this in Safe Harbor and currently in Privacy Shield. Afterwards, we will discuss a little bit the current status of Privacy Shield and if we can rely in these principles as an adequacy decision of the European Commission. And afterwards, what about if we conclude that we cannot rely on it, and what is the plan B for companies that somehow are currently sharing personal information with parties located in the United States of America. Okay, the truth is that transfers between member states of the European Union are free, provided that the companies comply with the general provisions of the GDPR, of course. However, when we talk about a transfer of personal data outside the European Union for what we call a third country, that is any country that is out of the economic European area, we have restrict conditions that are foreseen in the GDPR to do this transfer, to share personal data. And for example, this can happen when we are an United States company and we are processing European Union personal data, or for example, in case we are an European Union company, but we are somehow subcontracting services to a United States company, for example, because we have entered into a hostage agreement or a cloud services agreement or a storage agreement, or for example, because we contracted a company that provides marketing automation platform or email marketing services like MailChimp, for example, and that is located in the United States. Okay, and if this happens, okay, if we do need to share data with okay, so if we do need to share if we do need to share personal data and transfer personal data to third countries, what GDPR sets for in Articles 44 to 50 is that that transfer shall only take place when the controller and the processor, or if the data importer and the data exporter, if they comply with the general conditions that are set forth in these articles. And the purpose of this is to ensure the level of protection of natural persons that is foreseen in the GDPR, because if we are dealing with transfer personal data to a country that does not have the same level of protection of privacy and personal data, we need to ensure somehow that such level of protection will be, or a similar level of protection will be implemented. So when are said transfers legitimate under the GDPR? For example, when the transfer takes place on the basis of what we call an adequacy decision of the European Commission. For example, the European Commission already decided that the following countries ensure an adequate level of protection. For example, it's the case of Argentina, Andorra, Canada, Faroe Islands, Guernsey, the Isle of Man, Israel, Jersey, Switzerland, Uruguay, and also the United States of America, limited to the Privacy Shield. So we can make a transfer of personal data under GDPR if we are transferring data to a territory, to a third country, that somehow ensures an adequate level of protection. When assessing if such country ensures an adequate level of protection, the European Commission will analyze the internal law of the third country. For example, it will analyze if in such country the laws and the legal system, if they respect human rights, if they respect fundamental freedoms, how do they deal with personal data protection, if they have one or more independent supervisory authorities in such country that may somehow enforce data protection rights, and this is an example of a condition that legitimates the transfer to a third country. And the truth is that Privacy Shield was considered a set of principles that ensured an adequate level of protection. Safe harbor also, but we will talk about that afterwards. So, besides this adequate decision of the Commission, in case we do not have an adequate decision, we do have another condition that may somehow legitimate the transfer to transfer of personal data to a third country, and it is the case when we the data importer and the data exporter between them, they somehow ensure appropriate safeguards. These appropriate safeguards are, for example, the BCRs, the binding corporate rules, if they are set forth according to the Article 47 of the GDPR. This is the case when a group of companies entered into an agreement in order to, and they commit to apply general data principles, they commit to respect data subjects' rights, and these BCRs, these binding corporate rules, shall be approved by the competent supervisory authority. In this case, if a group of undertakings of companies, if they entered into BCRs approved by a competent supervisory authority, the truth is that we do have legitimate grounds to make the transfer from the European Union to the United States of America, to an entity receiving data in the United States. Okay, so BCRs will be considered appropriate safeguards. The same thing happens, also appropriate safeguards are the standard contractual clauses previously approved by the Commission. And once again, this may be a solution when we are not a group of companies. When, for example, when I want to enter into an agreement with a provider, in this case, I may enter into standard contractual clauses to ensure that when receiving personal data controlled by me in the European Union, such entity located in the United States will comply with principles that are very similar to those foreseen in the GDPR regarding security measures, regarding confidentiality, regarding enforcement of data subjects' rights. Okay, and also another possibilities that are considered appropriate safeguards agreed between data importer and data exporter is the case, for example, of a code of conduct. The truth is that, as I previously said, both Privacy Shield in 2016 and Safe Harbor that was approved in 2000, both of them were considered by the European Union Commission as adequate decisions. However, the truth is that nothing lasts forever, and Safe Harbor didn't. And the truth is now we are now discussing if Privacy Shield will also resist, right, Nicole?
Yes. Hello, good afternoon, good morning to everyone. I'm feeling quite you are an advantage to us because you can see us, but well, as Sonia was saying, the USA backgrounds are not encouraging in this matter, as you may be aware of. The truth is that surprisingly, Safe Harbor was declared invalid by the Court of Justice of the European Union after an appeal that was made by this guy here called Maximilian Schrems. He was a law student from Austria that before the revelations that were done by Snowden, he took advantage on those declarations and he decided to sue Facebook in Ireland. In a first attempt, he just lodged a complaint before the Irish Supervisory Authority. This Supervisory Authority didn't give him any, well, they decided that the Facebook should not be accused because there was a lack of evidence about the reliability of the Snowden declarations. But the truth is that when Schrems appealed for the Court of Justice, surprisingly, the Court of Justice declared the Safe Harbor to be invalid. And this was basically because since the beginning, Safe Harbor was severely criticized by experts, namely because of what Sonia somehow said here, is that this is a different system from the majority of the adequacy decisions that we have with other countries. To be compliant with the Privacy Shield, it's an option for companies. If, for example, you go for a transfer for the New Zealand, you do not have to ensure or to look if the company based in the New Zealand is self-certified in some sort of a system. You just have the insurance that the local laws from the New Zealand comply with the GDPR requirements in what concerns data protection. In the case of the USA, this is a self-certification system, so it's an option for the organizations to be compliant with Privacy Shield or not. So this is, from the beginning, one issue that concerns data protection experts in the EU. The second question, of course, is the fact that you do not have a fully independent supervisory authority in the United States with regard to data protection issues. These issues are supervised by the Federal Trade Commission that holds a lot of different departments besides data protection, including competence. So this is an issue that also concerns experts in the EU with regard to data protection. So, after Safe Harbor was declared invalid, for 9 months, we were waiting for a new adequacy decision for the United States. And that was when the Privacy Shield was approved and entered into force. Some improvements were made in the Privacy Shield agreement. However, the Trump administration maintained the emphasis in the needs regarding national security. So this is a question, okay? In the United States, we do have cultural backgrounds very strict in what comes national security. They do concern about this, and we all are aware that they think about national security in a different way that we think in Europe. So the emphasis that they give to this concept, to the needs with regard to national security, also have some implications in what concerns the data protection issues. Because for them, from their perspective, looking at the tourist criminal background for him to go to the United States, it's assumed to be normal. And of course, in Europe, we have the principle of innocence. So we are not checking criminal backgrounds in an American tourist just because he's coming into Europe. So this is the difference. This led, of course, to some distrust in this adequacy decision, because the truth is that as long as the national security needs keep the importance they have in the United States, this, of course, will lead to a minor concern in what concerns data protection issues. So the point was, of course, when some EU institutions started to show some concern in what comes the Privacy Shield. Not only the experts, not only lawyers that had experienced knowledges in data protection, not only professors in college, but also since the beginning of and after the approval of the Privacy Shield, the EU institutions started to show some concerns again with regard to the Privacy Shield system. So Article 29 Working Party was the first on April 2016. He said that the draft adequacy decision does not oblige organizations to delete data if they are no longer necessary. The US administration, again, here we go again with the national security principle. The US administration does not fully exclude the continued collection of massive and indiscriminate data. And concerns remains too as whether the ombudsperson has sufficient powers to function effectively. So again, the fact that the United States do not have a supervisory authority fully independent to supervise data protection, personal data breaches. Then we had the European Data Protection Supervisory on May 2016, so 1 month later. And again, the EDPS showed some concerns and said that robust improvements are needed in order to achieve a solid framework stable in the long term. But the main decision on this issue was maybe the 2 calls for the suspension of the Privacy Shield that were made by the Parliament. The first one was done in April 2017. But the second one, and maybe the most scary, was done in July this year, where the Parliament considers that unless the US fully complies with the level of protection required by the EU, which means it's like saying, you, United States, this is a message for the US administration, you are not an exception in this world, you need to comply just like other third countries do comply with data protection requirements that are foreseen in the General Data Protection Regulation. So, although, So the point is, should we rely, no. Sorry. Should we rely or not on Privacy Shield? So the first question that you may have is, if the EU call from the Parliament is enforceable for the European Union, or for the validation of the Privacy Shield or not. It isn't. So the European Parliament calls for the suspension, but only the European Commission or the Court of Justice can invalidate the Privacy Shield or any other adequacy decision. So this is more like an ultimate, a recommendation that comes from the Parliament to the Commission to call for the suspension. But of course, the final decision will be from the European Commission, and Vera Jourova, the European Commissioner that is leading the Privacy Shield negotiation, said several times she was losing her patient on the United States. So, Privacy Shield is under revision. Privacy Shield had its second annual review now in late October 2018, so about 3 or 4 weeks ago. And most of the USA owners of this process are convinced that the improvements made should be enough to enforce data protection requirements from the EU in those companies that adhered to the Privacy Shield. They inclusively they published a joint statement, a joint press release. So Vera Jourova, which is the EU Commissioner for the Privacy Shield, and I'm sorry, let me just check here the name for, the Secretary of the State Department that is also responsible for these negotiations of the Privacy Shield. They published a joint press release where they are stating that they are doing their best efforts to comply with the GDPR requirements. So what is expected before the end of this year is that the EU Commission will issue one report with regard to these efforts that were made between both parties to revise Privacy Shield in an adequate manner. So our message here for you today is, of course, hope for the best, but be prepared for the worst. So this is the main messages that we have been sending to our clients. We should expect Privacy Shield to be a reliable solution, but we had a bad experience before with the Safe Harbor. And the truth is that the differences between Safe Harbor and Privacy Shield are not sufficiently big to ensure adequacy as it is required by the GDPR. This means that, of course, and going back to what Sonia said before, although you may look for your certification jointly with the Privacy Shield framework, you should also bear in mind some alternative solutions like the standard contractual clauses. Maybe these are the easiest ones because, as Sonia said, the binding corporate rules are only applicable for undertakings, and the codes of conduct are not also an easy task to perform. Basically because binding corporate rules and the codes of conduct need to be approved by the supervisory authority, and usually this takes a long time. And we do know that companies need decisions for yesterday, not for tomorrow. So maybe the standard contractual clauses, which are clauses that were previously approved by the European Commission, would be the easiest and the fastest additional safeguards that you should consider jointly with the Privacy Shield framework if you feel like you want to join the Privacy Shield framework. Of course, if the standard contractual clauses are signed, The Privacy Shield.
Sometimes they are already signed and they are named as a data transfer agreement, for example, and they are absolutely in compliance and they are just the same as the standard contractual clauses. Sometimes the companies do not name it as standard contractual clauses, but the data transfer agreements are absolutely in compliance with these clauses.
But it's important to set out that the standard contractual clauses cannot be negotiated. So these are contractual clauses that were previously approved by the European Commission, and the parties should not change unless it is expressly identified as optional in the standard contractual clauses draft. And you can find those drafts in these links. Don't worry, you don't need to copy or write down the link, because I'm sure you will receive this slideshow. But basically, this is where you will be able to find the drafts from the standard contractual clauses. When you look at these links, you will be surprised with the fact that these contractual clauses are still approved under the 95 directive, which is the previous EU diploma from the GDPR. So before the GDPR, we had the 95 directive that needed transposition from the member states for his local laws, different from the GDPR that was executed directly with the member states. But the truth is that at this point and at this date, the EU Commission has not changed or updated these clauses for the GDPR framework. So these are still the valid ones to be used if, for example, you want to sign a transfer agreement for tomorrow. So, for sure you know that the hottest theme on these days will be the Brexit. So we had Privacy Shield, but by the time we were preparing this webinar for the Privacy Shield, we have noticed that we have another hot subject coming out, which is the Brexit. So our point here, we had the first draft of agreement presented this week by the United Kingdom, or last week, I think so. We still do not have any reply from the EU institutions, so we are looking forward to see what will the EU institutions reply to this agreement proposal. And we are counting on you to join us at the next webinar, maybe in the first trimester of 2019, if we get any news with regard to the Brexit, because this will also affect the data processing transfer, so the transfer of personal data. So thank you very much for your presence here today. We hope you have enjoyed it. Just leave your comments, suggestions, and I'm sorry, we have a message here.
Okay, so please, as Nicole was saying, yes, continue.
No, I was just saying that thank you very much for being with us today. We are hoping to see you in Brexit webinar and over all the webinars that we provide to you with this sort of information with regard to data protection issues. And I don't know.
Please feel free to send any messages, any comments that you may have, any queries, any questions. Please send them to Nicole or to me to these email addresses, or to the email address that was provided in our invitation to the webinar. Thank you so much. Thank you. Bye bye.
Bye. Thank you.
Bye.